McEowen, ag law specialist and tax professor at the Washburn School of Law. Time for another Ag in the Courtroom. And Roger, we have a couple of big issues to talk about this time around. And one of those is really propped up again, and that's these conservation easements. What are they? What aren't they? What are the courts saying as folks are really up in arms about these?
Well, it's the IRS that gets excised about these because it gives the possibility of a farmer or rancher or landowner or really anybody else who's got qualified property, but the focus being for farmers and ranchers. If I've got land that has a characteristic associated with it such that there's a nice view shed that we could preserve or something historical about the property, then I can find a qualified charity such as a land trust and put an easement restriction on my property, deed the property over to the charity and get a nice charitable deduction for that, because the charity, of course, is a charitable organization that gives me a tax break. And I still get to use the property. I can still farm it. I can still graze it. I can use it for agricultural purposes. I can derive money from it, just like I was before. It's just it cannot be developed, and the view needs to be preserved, whatever the case might be. And we often see these in areas overlooking a watershed, such as the Missouri River, the Mississippi River. There are some of these in Kansas and the Flint Hills. There are some of them out in the Great Bend area, preserving certain types of natural resources. So the Congress a number of years ago wanted to incentivize the preservation of that type of land. So they create this code section that says that if you grant a permanent conservation easement on your property, donate that to a qualified charity, such as a land trust, then you can get a deduction for that. Well, as you can imagine, it's not just a tax break that's given away. There are a lot of requirements that have to be satisfied in order to comply with that and to get the charitable deduction. And IRS and Treasury have written the regulations behind the statute, and those regulations are very, very specific as to what the landowner must do to preserve the perpetual nature of the easement.
Well, it's one of those that has been in a lot of discussions, things simply like this. What you're saying is more from a tax benefit, rather than, say, if you give this to one of these organizations maybe could resell that, and somehow the federal government could be in more control of that land, or come in and do some things that personal property and property rights could be extinguished. That there's a lot of confusion when it comes to these.
Yeah, that's not the aspect that we're talking about today. That's something that's totally different. But what I'm talking about are the technical details that the IRS requires for the landowner to get a charitable deduction on the tax return. And Ken, many times, as I read the cases on these, many times the claim deduction is in the millions upon millions of dollars. I've seen these in excess of $30 million. Because what you're doing is you're taking the before easement restriction value of the land and comparing that with the post easement restriction value of the land. So you're getting a value of that restriction, and that's your charitable deduction. One of the issues, and I talked to Judge Paris on the tax court about this a year ago when she spoke at my conference in South Dakota. And I asked her, I said, Judge, how many cases involving agriculture on these conservation easement issues are currently before the tax court? And she said there were docketed at that time over 150 on the tax court's docket. There are literally thousands of these across the country. And we have a case right now. Tax court decided it just a few weeks ago. It's now an appeal to the U.S. Circuit Court of Appeals for the Sixth Circuit. And the issue in that one is, what must the deed language say to preserve the perpetual nature of the easement in case government action by eminent domain condemns the land and erases the easement? That's the one thing that can make that easement non-perpetual. And there's a specific reg that says how you allocate the proceeds, and they're battling over the language in the deed in that case. And I'll tell you, that's standard language that has actually been used in thousands of cases. So if IRS wins that case, they're going to be able to obliterate hundreds upon hundreds of these conservation easements in terms of wiping out the charitable deduction. Judge Holmes on the tax court dissented in that case. And so the landowner has latched on to the Holmes dissent in the Sixth Circuit. We'll see what happens, but big implications potentially on the deduction side of things, depending on what the Sixth Circuit says.
Dr. Roger McEowen from the Washburn School of Law is joining us. Let's take a break, come back with more in just a moment. Timeliness, we don't know, but a lot of discussion of ending stepped up basis when it comes to transfer of assets upon death, or all these tax implications. What can farmers and ranchers be doing to kind of prepare themselves if and when this happens?
Yeah, that's a real good question. I don't have a clear answer for anybody on that one because for a couple of reasons. One, if this legislation does become law, we still don't know what the effective date would be. Some of this has a retroactive effective date back to the beginning of this year. Some of it would be effective starting in 2022. So that's the first issue that we have right there. And that does raise some constitutional concerns also if they try to impose a tax increase on a retroactive basis. But a lot of questions here. What if capital gain rate goes up? What if capital gains are imposed at death rather than when the heir sells the property? So is death the taxable event? Are we trying to shift to more like a Canadian system rather than in combination with the existing system that we have here? What if the exemption from federal estate tax goes way down, say to 3.5 to 5 million from its current level of 11.7? What does that mean for continuity of the farming operation? Would I have to sell off assets to pay taxes associated with death? What do I need to do right now? What can I do to help prevent that from harming my operation? You may have seen it. It was just a few days ago that University of Illinois Farm Doc put out a publication, and they estimated that if these provisions, the change in the federal estate tax exemption, the change in the capital gain rule, if those were to become effective, the average Illinois grain farming operation would face an increased tax at death of $500,000. That's on the average. Kansas Farm Management Association data, they're getting ready to do the same thing. And I think the estimates are right now would be that the data is going to show something very common to Illinois. So, what can you do at this point in time? Well, be flexible. Check your existing estate planning documents to make sure you've got enough flexibility in the language in those documents to be able to deal with changes as they come in. From a technical standpoint, as lawyers, we worry about or we utilize disclaimer language, we utilize certain types of trusts, but we're looking for flexibility in language that's not locking us into certain dollar amounts going to a spouse or going to kids, because that exemption could change. And so we want to have language that fluctuates to take into account any change that Congress might impose on us. Other than that, make sure that other pieces of an estate or succession plan are in place. We want to have powers of attorney in place. That's both for financial reasons and healthcare reasons. And we want to make sure that we have property titled appropriately and watch the joint tenancy issue if you have sufficient size. So, just kind of buttoning things up right now, kind of holding still until we see what the rules are actually going to be.
All right, Roger. Now, if folks want to learn more about these issues we've talked about and other things, you have a blog. How can folks access that?
Yeah, they can access that off my homepage on my website, which is washburn.edu/WALTR, or just do an internet search for Washburn Waltr, WALTR, and they'll find the homepage. And then down the left side of that homepage is the access to the blog. And you can also sign up to get an email alert when I add something to it. But I write about these things, have been frequently this spring. So all that information is there.
Well, I know it is travel time for you. You're crisscrossing the country now talking about these and other updates. So travel safe, and we look forward to talking with you next month.
Thank you, Ken.
Dr. Roger McEowen, who is a tax professor and law professor there at the Washburn School of Law, has joined us. Stay with us, more in a moment.